So hello, everybody, and welcome to Coho BC's online session, Partnership Agreements and Legal Considerations when Co-Owning. We are delighted today to be joined by Ryan Griffin of Bell Alliance, who will introduce himself a little further on, but who is a leader and with the leading team of lawyers in the province doing co-ownership agreements for friends, families, strangers. I'm really excited to have him and his expertise here today. My name is Noam Dolgan. I'm a real estate agent here in Vancouver with Helen Merch Realty and a co-founder of Coho BC. And I'm delighted to be hosting this conversation. Before we begin, we'd like to take a moment to acknowledge that we are on the ancestral and unceded and spiritual homeland of many different nations across the province. And we take the responsibility of land stewardship as people living on the land and as owners of land very seriously, and want to continue that long tradition that has existed. So what is Coho BC? What is the group that has brought us here today? Coho BC works to promote co-ownership as a viable and valuable housing option across the province, to provide resources and professional support to assist groups going through the co-ownership process, to assist in the creation of co-ownership groups through a dating pool and in-person sessions and chances to kind of meet other people and find the right partners for the right property for you. And we work to facilitate the resale of shared property interests to potential new buyers. We'll talk more about resale when we talk about the legal agreements. Who we are is a collection of professionals with experience and expertise in co-ownership, realtors such as myself, lawyers such as Ryan. We have builders, financial institutions, architects, mediators, and even a matchmaking team, all with really the understanding and the knowledge and the experience around this topic to guide you successfully from beginning to end of the process, wherever you are, be it in property acquisition or in resale, or just needing some consultation for your family situation, whatever it might be. So don't reinvent the wheel, use the experts, and we're here to help you be successful. We like to think that we're breaking ground here, but this is part of an international movement. It's not just a BC only thing. These are examples of organizations working in the co-ownership, residential co-ownership space across North America, Europe, Australia. So it's really an exciting movement that people are focused on to deal with some of the issues of social isolation and affordability that's happening across the globe. It's also not a new concept. It's been going on for years and generations even. It's just getting more and more popular. So much so that we're seeing in recent surveys that anywhere from 33% to 74% of non-owners see co-ownership as one of their only pathways or their most or a preferred pathway into the housing market. And when you look broadly, there's definitely between 7 and 15% of people who really see this as a possible pathway for themselves, of all types of people. So it's definitely something that could become a major part of our real estate and of our reality in the years to come. And so we want to make sure we're setting people up, as I said, for success. So what makes a good co-ownership work? I like to think that there are 4 parts that go into making a solid agreement: a good property, a good partner, a pathway to financing, and a strong legal and partnership agreement. And with these 4 pieces in place, co-ownership becomes a really an option for many and most people. So we're delighted to focus on that legal agreement in today's session. What are the advantages? That was a typo there. The advantages, there are many advantages to co-ownership. Certainly you can know your neighbors, have community and support. which is a real change from the traditional strata model, where you're buying into a group of random strangers, and you don't necessarily know your community unless you've built a good solid community around you. But you can really have a good supportive housing environment. You can save money, certainly, if you do it right. You can get more space. You can share resources while you're living there. Have a higher quality of housing, or housing otherwise not available, like living in single family neighborhoods or standalone houses, small standalone houses like laneway homes. You can create financial synergy, where two people who couldn't otherwise own on their own can come together and achieve more together. And we like to think of this as a triple bottom line sustainable choice. It is socially, it is fiscally, and it's environmentally a better housing option for many. There are, of course, challenges. If there weren't challenges, then everybody would be doing it already. And this is where Ryan and the legal agreement becomes so key. So the challenges, the major ones we see, are around financing and mortgage. All owners must be on a mortgage together and could be held responsible for the whole amount. So you need to make sure you have good plans and systems in place around money and around responsibility and around what happens with delinquency. Talk about in a minute. Exit strategy, certainly. What happens when, it's an if or when, but really eventually it'll be when one of you wants to sell, someone dies or divorces, has to move for work, whatever it might be, right? Understanding how you plan to transition out of this when the time is right, what you do in terms of delinquency if someone stops paying, how do you deal with ongoing disagreements, or how do you avoid them around issues like repair, maintenance, noise. So again, this is where having the right professionals from the Coho team and the right lawyer can help you do a deliberative and thorough process before you get into the state of buying a home together, or selling or sharing your home to somebody, and make sure that you are set up for success with all those right pieces in place. So before we go on, I'll just introduce myself a little more. I said my name is Noam Dolgan. I'm a realtor here in Metro Vancouver, with a specialization in co-ownership, sustainable living, first-time buyers. Really, I like to think real homes for real people and outside of the box real estate thinking. So trying to create better and more available housing. Before real estate, I was working in environmental education, institutional greening, and community engagement. So this type of a vision was really a natural extension of the kind of work that I was doing. We do have two other members of the Coho BC community here as well. David Hale, a realtor in Victoria and the founder of Shared Home Ownership Victoria, and Brian Horowitz, a realtor in the based out of Cowichan, but working in the Mid-Island, Gulf Islands, and our rural land use specialists. And we're delighted to have them with us today as well. And we'll meet them at the end when we get to questions and things like that, because I'm sure they'll have something to add at that point. But you're not here to talk to us right now. There's lots of other Coho events and opportunities and chances to do that. Today we're here to listen to Ryan Griffin, a lawyer with Bell Alliance, a co-ownership, I believe, estate and real estate specialist. And we're delighted to have Ryan here today. And I will stop my screen share so he can pop his up. And we look forward to hearing what you have to impart to us today. Thank you so much for coming. And yeah.
Okay. Thank you, Noam. So yeah, as Noam mentioned, I have worked my way into becoming somewhat of a specialist in co-ownership agreements. It's not sure exactly what the path was to get there, but here we are. So I do a number of co-ownership agreements on a very regular basis. In terms of the types of co-ownership agreements that Noam has referenced, as well as co-ownership agreements related to just straight investment structures, corporate structures, and everything else. But the focus today is more on the type of co-ownership agreement where we're going to have parties living in the property, also investment type of co-ownership agreements as well. But I'll get into some of those structures as we move forward here. So co-owning property. So bit of a background here before we get into more of the specifics. So co-owning property, you can have two different types of ownership in when you have more than one person on title, either joint tenants or tenants in common. Joint tenants, you have essentially if all of the parties are going to be joint tenants together, they're all going to own the property in the share of basically dividing 100 by the number of people on title as joint tenants. I noticed that there's a hand raised. I'm gonna maybe hold off on questions until closer to the end, know if that's all right with you. So maybe feel free to make some notes for any questions that you have. I'm happy to go back to some of these pages after we're all done here. But yeah, I'll keep going here. So joint tenants is basically dividing the property by the number of owners. So if you have, say, 3 tenants or 3 owners on title, each one is going to be a 1/3 owner naturally. What's important there is survivorship. So when you have a party die potentially, the property automatically, when you have 3 owners that are joint tenants, the property automatically transfers to those 2 remaining tenants who then become 50-50 owners. So it's an important distinguishment. Often joint tenants is only used in the case of spouses, where it's naturally going to occur by way of the will anyways. Tenants in common is more frequently used in co-ownership type structures where you have potentially 2 different spouses that are going to be on title. And that's, or where you might have siblings who are on title, or basically any situation where you don't necessarily want your interest to automatically be transferring to the other owner on title. You can also have a hybrid, which is where you have potentially 2 spouses. So I've given an example there. You have the 2 joint tenants, so A and B as joint tenants, they might be spouses, as to an undivided 40 out of 100 interest. So if both A and B die, their estate would take over as the remaining owner of that 40% interest. Of course, that's subject to whatever the co-ownership says, and I'll get into situations that might happen with respect to death shortly here. So getting into more of the specifics, so preliminary considerations. So Noam and the whole team there will kind of be involved with respect to more of this end of things. So who's going to be owning the property? Is everybody going to be going on title? So that might be a reference, that's a bit of a reference to something like a bare trust. So a situation where you may not want to have all parties on title. I can get into that a little bit further in this presentation, and happy to answer any questions that anybody might have with respect to that. And then refinancing down the road. So that's an important consideration that not a lot of people think about up front. It's one thing to have the co-ownership agreement set up with respect to your current structure, but as of right now, a lot of terms for loans are only 3 years. And so thinking about what might happen in the case of a refinance down the road, if you might, because ultimately you're going to be renegotiating at that point. And it might be that one party wants to pay down the loan faster or has extra cash at that time. So that's a consideration that certainly wants to be included in a co-ownership agreement. And then renovations. Are there any immediate expenses to consider? So not just your costs of the property, but also how is that going to be divided? And again, I'm going to get into some of the different types of co-ownership, proportionate ownership interest here in a second, but something to consider as well going forward. So the co-ownership agreement itself kind of outlined a few general areas that I'm going to keep coming back to with respect to what the real meat of the co-ownership agreement will cover. So first, proportionate ownership interests. So the participation on the increase in value of the property, financial responsibilities. This is really what I would consider to be the most important consideration when you're entering into a co-ownership agreement, is who's going to get what, who's going to be responsible for what. And this is It may not be a legal consideration necessarily, but this is a really important detail to sort out well in advance of the actual completion date, is determining how things are going to be split. So I've outlined a few different types of co-ownership, proportionate ownership interests here, and also wanted to touch on a note that I always recommend considering up front, which is equitability. It's one thing to say that you want to just go into a co-ownership agreement as, say, 75 and 25 with somebody, and if both parties agree, there's absolutely nothing stopping anybody from doing that. It's ultimately, freedom of contract is one of the things that is the cornerstones of our legal system, and there's nothing stopping anybody from deciding that they want to contract in that way. However, we want to think about things like marketability and avoiding litigation down the road. So when I talk about marketability, of course, co-ownership agreements are not standalone. Well, the co-ownership agreement interest is not a standalone right as to a real estate property. It's a share of a property. So in a way, you're taking either a freehold or a stratified property and saying, I own a share of this. And to market it is certainly possible, and that's where Noam steps in with his expertise, and he's able to provide the ability to potentially market a share of a standalone property. But marketability of that share is dependent on the agreement that's currently in place. And so saying that you want upfront to have, well, we're going to go 60-40, we're just going to make those numbers up in part because that's what the investments are going to be, for example, or we just feel that that's roughly what the property is worth. Coming back to sell that share down the road can be problematic if a future buyer is wondering why their share is only 40%. So things to consider, and I've kind of outlined a few potential equitable ownership structures that I generally recommend. One being mock stratification. Second being investment with a rental readjustment, or what I would call almost like an investment into a corporate share type of structure, and then a hybrid. So getting further into those. Mock stratification. So what I mean by that is basically we're taking the Strata Property Act and trying our best to apply it to a ownership agreement. So basically saying I have a share that is based in value on what might be, for example, a hypothetical appraisal. So I've given an example of how that would work. So you have a property that's worth $2 million as a whole. Let's say that's two separate suites, suite A and suite B, we call them. We're going to, and appraisers can do this, we can do potential hypothetical appraisals. So saying that suite A is worth, if it were marketable on the on MLS as a separate individual suite, it would be worth potentially 1.5 million, whereas suite B would be worth 1 million. That's where we would base our percentage of that property worth on. So your proportionate ownership interest would be suite A having a 60% interest, so 1.5 out of the total of the two. And then suite B having the opposite of that, 40%. So then applying that to the purchase price, you'd have party A being responsible for 1.2 million of the $2 million property, and party B having $800,000 as their responsibility towards the property's purchase price. This also helps with renovation. So renovation of owned properties can be problematic. Not always does dollar in mean dollar out. And especially when you want to try to separate out those individual suites. So trying your best to say, I own this share. I want full independence to be able to replace the countertops if I want, or to replace all the flooring in the unit. And I'm fine with it being my responsibility, but being reimbursed for that is what's potentially problematic. Or because, as I say, dollar in isn't dollar out. So you might say, I am going to do $100,000 of renovations, but you may not get that $100,000 back. So determining, as a hypothetical, we might do a appraisal before and after that renovation. That's at the responsibility of the party that's entering into the renovate or doing the renovation at their cost. to do. So you might have a hypothetical appraisal that happens before and after that renovation that reevaluates the percentage ownership interests. And then, as I mentioned earlier, we're trying our best here, if this is going to be the structure, to resemble what the independent legal unit would be, so that it makes marketability a little bit easier. The second structure is what I would call like the investment structure. So basically you determine percentage ownership based on a preset percentage or on investment, which is what a lot of people often choose to do. They say, well, I can come forward with, we're going to do a down payment of $500,000. I'm able to come forward with $200,000 of that. You're able to come forward with $300,000. So we're going to do a 60-40 split on that basis. There can also be different structures based on financing. So that shouldn't be the be all end all for that type of a structure. If you're just doing a down payment of $500,000, there can also be the portion of financing up and above that to, say, the $2 million purchase price that can be split. And I'm not going to get too into the financing side of things. It's not really my wheelhouse, but I know that there are banks out there that are able to do different loans under one umbrella loan structure. And on that side note, financing is inevitably problematic because of, as Noah mentioned, everybody's going to be signing off on everybody else's loans. So if you're even though you might be taking out a separate loan and we agree under the co-ownership agreement that there's going to be separate responsibility, if one person defaults, the ultimate worst case scenario being foreclosure can't necessarily be avoided, although the co-ownership agreement, and I'll go into this in a second, can help to alleviate some of that risk with our exit strategies that I'll go into in a little bit here. Coming back to this investment structure. So where the equitable side of this comes in is with respect to the readjustment for potential rent. So we're thinking of this as an investment into like an investment property where there might be two separate suites. Each of those suites potentially seeking a different rent on the market. So market rents, let's say for suite A would be $4,000 a month, market rent for suite B being $2,500. Ultimately, to get to an equitable perspective, what we would want to do is try to have each of these determined based on the or let's say if the parties are moving into the units, I should start with that. We want to have each of these somehow accounted for, because the parties would otherwise be receiving the total of $6,500 per month in rent if both suites were being rented out. And obviously owner B, if we're having owner B living in suite B of $2,500 a month and the market rent, is getting the short end of the stick. So the reevaluation that I recommend in this type of structure to get to a more equitable perspective is that owner A would pay $4,000 a month, which is the market rent, to a joint account. Owner B would pay $2,500 a month. So you have the total of $6,500 a month in that joint account. That's then divided by 50/50 or divided by 2. So we have $3,250 per month that'd be paid back to each party. So simplified, owner A would pay $750 per month to owner B on the basis that owner B is getting the lower quality of suite to be living in. So these are just potential options that are available to bring things to a more, I keep using that buzzword of equitable perspective or stance, that we have the ability to potentially market these units down the road, but also keeping things from potential litigation down the road and just sore or hard feelings between the parties. If one party says, well, how come, we may have agreed to this prior at a prior stage, but I'm just not comfortable with the situation. And I'm losing out on all this extra rent that we would otherwise would have received. So keeping that in mind going forward. So coming back to this co-ownership agreement as a whole, so financial responsibilities. So on the basis, we're leaving the proportionate ownership interests aside, that will inevitably there will be a bit of a thread through all of this, because these, as I mentioned earlier, proportionate ownership interest probably the most important factor. Financial responsibility, so financing, as I touched on earlier, there are financing options available for parties to have separate loans. Inevitably, each party will be signing off on the mortgage. So anytime there is a refinance that occurs, all of the parties need to sign off. No party can ever get a mortgage on title without all of the parties that are on title signing off. There would be in any co-ownership agreement, I would highly recommend including wording that does make it a breach of any co-ownership agreement if anybody's going to somehow put a lien or a mortgage or any other financial charge on the property. It should be absolutely restricted from any party being able to do that. And then inter-party loans, I often get this question. So we have, let's say, a situation where one party has a more significant down payment, or putting it a different way, let's say one party can afford more than the other party can, like upfront, and there's just one party doesn't have the ability to get to, say, the 20% down payment that's required by the bank. Some parties have chosen to do just an inter-party loan that is included in the co-ownership agreement and is paid down on a schedule that would be set out therein. So if there's say a $400,000 down payment required, and we're going 50-50, but one party only has $150,000 that they can bring forward, and the other party has that extra $50,000 above their otherwise required, so $200,000. They might decide, well, we're going to give you a loan of the balance or the difference so that you can pay us back on the schedule that we decide, and that allows us to enter into a purchase a little bit earlier and get to the stage that we want to be at, that otherwise we might have had to wait for you to make your additional payments. So there are structures in place. Mortgages are not one of those structures. Putting a second mortgage on title is a breach of your initial mortgage, and you also can't mortgage your own property. So promissory notes, and there are other security, there is other security available, but as a whole, being co-owners of the property, we would make this a case of default if that inter-party loan is not paid off, meaning there will be exit strategies available, which I'll get into later in this presentation. Moving on to use of the property. So this is dependent on what the property is going to be used for. If it's going to be a rental property with just investments into it, or if we're going to be more of a strata type property, like a mock stratification. Do we want to have limited common property? Is there going to be common spaces? Is it going to be split? There's going to be specific sublots. Or is it going to be just a huge communal space? We're going to have just owners that are, based on their contribution to the property, are all able to live in this space, all able to use the kitchen, all able to use all the facilities, and everybody's going to split all the expenses based on their percentage ownership interest. So either the investment or another predetermined number. And then rentals. So if there's, let's say a situation where there's 3 suites, is that third suite going to be rented out? Is there a restriction against either the parties from renting out their own suite? Is there more autonomy? Can those parties decide that they want to rent it out at any point in the future if they so decide? You know, those kinds of things to consider. And then also, what would the distribution of those percentage of rents be? So would one party, if they decide we want to go with the more autonomous based system, would we have a party that is, if they decide they want to rent out their suite, is that the rental income going to go entirely to them, or is it going to be split according to the percentage ownership interests? So all things to consider there, and certainly things that would be recommended to be included in the co-ownership agreement. Insurance, so property insurance, obviously a must, but also recommending that life insurance for parties be available. So if something does happen, there's not more of a financial strain on the party that isn't dealing with any potential life altering events. So that would be certainly something that would also be recommended to be included. Renovations, we've kind of touched on this a little bit already. So as I mentioned, definitely a point of that I've seen having issues in the past, and how to deal with situations where one party wants to renovate but the other party doesn't. Is there going to be a responsibility for the parties to provide drawings or renderings of those renovations in advance of moving forward? Is there going to be a split based on percentage ownership interests? So all things considered, I always feel that when I bring renovation, the topic of renovations up, it's often something that is not really considered to be that important up front. Oftentimes when parties decide they want to move in, they often either want to do a ton of renovations immediately or think, well, we're never going to need to do renovations. And inevitably, it's something that's going to likely come up at some point. And then also determining whether, like, what the distinction is between a renovation and maintenance. Is there there are obviously some things that are going to be considered to be split between the parties no matter what. So replacing the roof might be one thing that should be split between the parties. But doing something like replacing for a better example, replacing windows might be something that if the window needs to be replaced, would be something that should be split according to proportionate ownership interests. However, doing a renovation of those windows, so making the windows bigger or adding a window, might be something that might be more of a renovation-based expense. So determining who's going to be responsible for each of those. And then some more minor, but also important details, accounting. So I always recommend having a joint account in place so that everybody knows where the funds are going to, everybody knows where the funds are coming out of, including the mortgage, and then also for accountability or transparency for who's paid for what. And then authorization for expenses. So at what point do both parties or all of the parties need to agree to an expense? So often, I recommend something like $1,000 threshold, or unless in the case of an emergency, that anybody can make any common expense payment up to a certain amount without requiring the joint consent of all parties. But this ultimately comes down to decision making, which is something that would also be addressed as a whole in the outset of the co-ownership agreement. And then a reserve fund is something that I've recommended or often recommend with respect to, especially when it's a stratification or mock stratification type structure, have something in place in case there's a major expense like having to replace the roof. And then dispute resolution. So arbitration is generally what I recommend under the Commercial Arbitration Act for that, but dealing with that upfront. Now moving on to exit strategies. This is, other than proportionate ownership interests, I'd say this is the most important portion of co-ownership agreements and what often I get a lot of questions about. So the main exit strategies we'll get into: right of first refusal, a triggered buyout option, shotgun clause, and death. So getting into each of those, death is more dealt with on a case-by-case basis. So we have two general structures. One is that it's dealt with under more of a triggered buyout event, which I'll get into in a second here. And the other is to say, if one party dies, and this is really determining what the relationship between the party is, or the parties are, and also the use of the property. So if it's more of an investment type structure, you might have a situation where you just want that party's share to be liquidated in the case of that party's death. So in that case, you would basically say, okay, is that this party has died, we want to basically ensure that the estate doesn't necessarily need to move forward here. So we're going to liquidate that party's share. And if the estate decides at some point that they want to enter into this, that can be renegotiated at the time, but there's no requirement for the parties to enter into a new co-ownership agreement with the estate. The alternative being that the estate automatically becomes, and they do naturally become, the heir of all of their responsibilities and liabilities in the case of death. The estate would then step into the shoes of the co-owner who's deceased, and the beneficiaries would therefore, we take over that party's share in the co-ownership agreement. So that's a situation that might not make sense in some circumstances, which is why some people might choose to override that and say that in the case of death, this party's share is going to be liquidated. We're automatically going to have the right to buy them out. So getting further into the others here. So right of first refusal. So the general structure is party A wishes to exit the agreement. Party A offers for sale their share of the property to add its fair market value to Party B. Party B has a set number of days to buy out Party A at the fair market value, which is going to be a number that's going to be determined according to a fairly detailed clause in the co-ownership agreement, which would be basically going through a list of priorities. So the parties agreement, if the parties can agree to fair market value, and then moving through there to appraisal, and then if necessary, a second appraisal, and then if necessary, an average of those two, if there's a real big disagreement over where the fair market value would be between the parties. After that a set number of days, if Party B does not decide to buy out Party A at the fair market value, then after that set number of days, or if the Party B just rejects the offer, then the entire property would be listed for sale. The optional requirement in here, which I've been alluding to a few times, is with respect to marketability of that party's share. So inserting option or that it before the sale of the property as a whole would be that one or both parties can choose to have a set period of time to market their share for sale to a third party buyer on the MLS or to any party that they choose to bring forward. That period of time should not be infinite. It's very important that Party A in this circumstance has the ability to be able to sell the property as a whole at some point. There needs to be that backstop. Party A in this situation might be in a situation where they just don't want to be in the agreement anymore, or they cannot be in the agreement anymore. Let's say they moved across the country, they need the funds from this property to be able to buy that out. Party B decides that they don't want to buy that other party's share out, but they also are being, for whatever reason, might be sticky about finding a third party buyer or whatever the circumstances are. So the timelines do need to consider a situation where a party needs to get out of the agreement as quickly as possible. The timelines also allow for the non-exiting party to arrange financing. And then also the third party buyer procedures. So this is what I was mentioning, that this is an area that I think we're developing a little bit more right now, which is that these shares in co-owned property do seem to be picking a bit of steam in terms of the marketability of them. So setting up more clear structures for how the properties a third party buyer might take over that interest. If there's a vetting period, for example, for the non-exiting party to be able to meet all of those potential buyers, and then the third party buyer being required to enter into the agreement so the co-ownership agreement that's already set up, requiring that third party buyer to enter into that agreement prior to the sale going firm should be a conditional or it would be required that the seller not list the property unless there's a condition saying the third party buyer must enter into the agreement or a co-ownership agreement prior to. And then triggered buyout options. So this is where we deal with default. So if one party does one of hundreds of things that could be considered as default under the agreement, basically anytime they do something that is not in compliance with the agreement. Now there's limits. We don't necessarily want to say that if a party, if the co-ownership agreement says that the parties are going to switch back and forth week to week on who takes the garbage out, we don't want to have that trigger a automatic buyout option. So there would be situations where there would be, this would be default would be triggered, and there would be a set period of time under which the defaulting party, the non-defaulting party is to provide notice to the defaulting party that that party is in default. And if they don't remedy that default within that set period of time, then there would be an option for the party, the non-defaulting party, to buy out the defaulting party's share for a set period of time, until which, or after which, the non-defaulting party can trigger sale of the whole property to a third party buyer. So in addition to default though, so we're not just dealing with default that would trigger this buyout option. It might be that death is something that would be triggering that option. So that's what I was referring to earlier. It's a situation where we would have essentially a liquidation of that party's share, mental incapacitation, And then divorce. So divorce is something that I get asked from time to time. So what happens if the other parties are in disagreement? Is this going to put our property in, potentially in jeopardy of whether or not we can, or it's going to be sold to liquidate assets to sell to, or to distribute to a party who has a claim? What I recommend, there's really not much that can be done other than a prenup between the parties who are entering into the agreement, which the other parties can't necessarily control. So the parties who are at concern here, so if we have parties A and B and then C and D, and parties C and D are, or A and B, sorry, are concerned that C and D might get divorced at some point. A and B can't force C and D to enter into a prenup. They're not parties to that arrangement. So all that they can do is say that if C and D, or if any parties end up in a situation where there's a separation agreement or a divorce that's being considered, we would have specific wording that would consider when that would be triggered. But that would allow an option for A and B to buy out C and D's share at its fair market value. So it's a triggering option that doesn't necessarily have to be utilized right away, but it does allow, if C and D are in a situation where the property is their only asset and they can't take money out of that asset, let's say it's a cottage or a recreation property that's not easily financed to pull money out of, that might be a situation where A and B would just buy C and D out if they can, to protect that asset. And then after the fact, they might say to C, let's say they've separated, and let's say C is one of the siblings of B, and they want C to come back in, they would then have the option at their own will to decide to bring them back into the co-ownership agreement at that time. That's really all that can be done in terms of divorce, and it's not the best option, it's not the best, it is the best option, but it's not, it doesn't necessarily seem ideal, but it's really all that can be done to avoid that.
And I'll just say, we see this with parents investing in their children sometimes. So what if you're giving a down payment and co-investing with your child, and you want to protect yourself in case of a divorce, you want to make sure that you can go on living with one child and not with the ex-husband or whatever it might be. This can be a mechanism to kind of protect that family investment and that family compound structure.
Definitely. Yeah. And there are other considerations in place where it's parents and children, especially if there's money that's being provided to the children in order to enter into this. That's a whole rabbit hole that I won't necessarily go too far into, other than saying that there are options in place to treat it as a loan. So having loan documentation in place, to say that this is a loan to, say it's a daughter with a potential son-in-law, that this loan, in order to buy into this property, is made out to our daughter only. And then if there's a divorce that happens between the daughter and the son-in-law at some point in the future, that loan would then be called back. And so there's that money is protected from being a potential claim by the son. There's, as I say, this is mixing in family law and estate planning and everything, so I won't go too much further into that, but do feel free to reach out at some point in the future if anybody has any questions about how that might work. Third exit strategy, shotgun. This is really, I would really recommend against shotgun clauses being included in co-ownership agreements. This is where the co-ownership is more akin to a shareholder agreement in a corporation. So you might have a situation where we have, well, the specifics of how it works is party A provides notice to B that A wishes to sell their share of the property to B at a set price. So they name a price. They say that I'm willing to sell it to you. They might say it's a great deal. Go ahead and buy it. You have this much time. There aren't a lot of mechanism or restrictions on how the shotgun is to be made. So in terms of timing, in terms of price, it's really up to the parties. And then if B fails to purchase A's shares at the named price, A might have the immediate right to buy B's shares at the same price. So if or vice, so basically saying, I'm going to buy you at this price. If you don't agree with it, then or sorry, if I'm going to sell to you at this price, if you don't agree to it, then I'm going to buy yours at the same price. Or alternatively, if you go a number of ways. You can also say, I'm going to sell to you my share at this price, but you also have the right to sorry, how that would, I'm mixing up my numbers here, but in any event, it's not something that I would recommend going with unless it's a strict investor type relationship, because we're dealing with situations where you have people living in the property, and we want to be, as I mentioned 100 times already, as equitable as possible with this type of a situation. So I don't generally recommend it. I'm happy to have further discussions with anybody that's curious on how the shotgun works. So I didn't do a very good job explaining how it works there, but I'm not going to bother going too much further into it because it's not recommended. Other considerations. So this is actually my last slide. So I'll get into a few questions that I often have. Actually, parents and children, we've just gone over some of that. Do you want to be cautious anytime that you're distributing funds to your kids, or even bringing your kids on as part owners of your property, on how that will impact any potential other beneficiaries' interest in your estate? So if you provide your children with the ability to buy into your property, and you provide them with, say, interest-free loans, or some kind of advantage that wouldn't otherwise be given to the other kids, or that is not necessarily an advantage that would be given to the children if they were just purchase property on the market, that's something that you want to review your wills for. So making sure that you're specifically acknowledging that you're giving one child a share that the other children aren't necessarily getting, or alternatively to distribute the same amount that you're providing to one child, distributing that to the other children. So saying we're giving you or gifting you a portion of our property for you to build a laneway on, for example. And so we're going to also gift the value of that laneway, essentially, depending on, there's a lot more in that, such as what the cost of the laneway is going to be, whether the kids are going to contribute any money, but essentially saying we're going to gift the value of that laneway to our other children as well, in cash or other monetary considerations. So important to keep in mind. I often get questions about rent-to-own structures and how that works. So saying one party doesn't have any money right now, we want to enter into a co-ownership agreement that allows them to gradually buy in a percentage ownership in the property. That is a very complicated situation. It can be done. I've done co-ownership agreements in the past where it's that type of a structure, but it requires that all parties are living in the property to avoid capital gains and property transfer taxes. And they also need to be related individuals if we're going to avoid property transfer taxes. So I shouldn't say avoid, but not be responsible or get an exemption from property transfer taxes. But rent-to-own structures can be done. It's important to consider what the fair market value is at any individual payment. So we might have, it's more akin to buying into a share of a company. So determining at any time that you buy a share of the company, what the value of that company is at the time that you buy into it. Same thing goes with the property. So if you want to have the party gradually making payments at their will, so whatever time they want, they can make an additional payment, they should be buying in based on the fair market value of the property at the time. Otherwise, there are other considerations, such as if there's other beneficiaries, like if it's a child, it's most often this type of structure is in place with children. So wanting to have them buy into a property to get into the market and gradually work their way into a percentage ownership interest. But if you're giving that advantage based on one value to your kids, so like the property value as of right now, if the property goes up by double in the next 5 years, and your kids are still buying in based on today's value, the other beneficiaries are going to be going, why is that? How can I make those contributions? Like, why is my one, why does my brother or sister get to basically buy into a property that was worth half the price 5 years ago, and you're sticking with that value? And then to kind of top things off, sometimes especially with parents and children and these rent to own structures, it's better to be just structured as a loan. But that's more, we're kind of veering away from the general structure where we're talking about here, which is more the co-ownerships in marketable units. So I think that is everything. So that concludes what I wanted to talk about. So I guess I'll open the floor, and maybe Noam, if you want to jump in as a moderator there, and I'm happy to answer any questions that anybody might have.
Well, Ryan, thank you so much. Clearly, there's a lot of information there, and I think the biggest lesson is that there's a lot of things that need to be considered, and that we can't necessarily lay them all out in a nice grid pattern or presentation for everybody. That people really need to do their due diligence, to sit down and talk with each other, to use professionals like yourself, to use people like Brian, David, and myself who know these questions to ask in advance, and to really kind of think through all the elements of what happens now on purchase, what happens ongoing with the property while we're managing it and living in it, and then what happens when it's time to exit this arrangement, and really answer all those questions well in advance, put it down on paper, and then have a guide to go back to. And I think I've heard you say that the point of a legal agreement is not to protect you in court, although it may come to that, but is to have a document to look at, to have your questions already answered, to have a plan for every contingency, so that you never find yourself going further down the road. So I'm going to invite people to raise their hands, to throw questions in the chat. I'll now set the security settings so you can unmute yourself. And I see our first person here is Brian Horowitz, our Vancouver Mid-Island specialist and rural land specialist. Brian, why don't you introduce yourself and ask your question?
Thanks, Noam. Hi, everyone. Thanks, Ryan. Hi, everyone. I'm part of the team here at CoBC, and wonderful to see these types of collaborations come together. It's been a pleasure working with Ryan because it really is a critical component to address that really separates this form of homeownership from your typical form of homeownership. But Ryan, I just wanted to ask you, something that resonated with me regarding matrimonial homes. Let's say that we have some clients coming together, and there's single parties, people aren't in a relationship. So would you include, and let's just say down the road, that single person gets into a relationship, and then all of a sudden there is common law type of, and then it becomes a matrimonial form of ownership. So would you automatically include a clause in the contract about the matrimonial stuff to deal with in a co-ownership agreement with two co-owners where they aren't in relationships, just to looking ahead in case they were to get into a relationship?
I don't always, I wouldn't say I automatically include it in every circumstance. It depends. Certainly if it's the type of situation where there's a married couple who's entering into a co-ownership with a single individual who's going to have a separate suite, and the intention is that this is going to be a long-term type of a situation, then I would recommend something in place then, and it should be at basically the married couple or the spouses in this situation would be saying upfront that the other party is permitted to split their share with a future spouse if they wish to do so, and there shouldn't be anything that would restrict them from doing that. All the costs of any registration with Land Title Office would of course need to go through, would be at the expense of the party that wants to be added, or the single person and that future person. And then also considerations with mortgages are also something to consider. So if you do want to add somebody to title, it's likely going to restrict or be a potential breach of your mortgage if you decide that you want to add another person to title. You've been approved on the basis of the people that are on title right now. And so the lenders will want to do an assessment of that other third party to make sure that they can also be added and they haven't, for example, declared bankruptcy in the last 7 years.
Okay. Another question I wanted to ask too, an agreement is between two parties, and when someone passes away or leaves the agreement, typically that agreement is nullified. So including a clause within the co-ownership agreement, if we have co-owners in an agreement, one co-owner were to pass away and someone else were to inherit that portion of interest, for that person to be bound to the terms of the agreement, because the initial agreement was between the deceased person.
So there would always be included in these agreements that it's binding on heirs and executors. And so the agreement would essentially just continue through to the estate and the beneficiaries, and they would automatically become responsible for all of the responsibilities that the deceased party had agreed to in the terms.
Great, thanks.
All right, we've got a number of questions coming in now from the floor. Thank you all. We'll start with Emily, whose hand went up first, and then we'll go back and forth in the chat and the people. Emily, please unmute yourself. Hello.
Hello. Thanks. Can you hear me?
Yep.
Great. So I guess my question is about if there were like more parties involved, what the best ownership model or structure would be. Let's say that's like part A, and then part B would be let's say that two properties next door to each other are bought by this group of people. What would be the right kind of structure to be able to hold both those properties owned by all the people who are investing into it?
So when you say third, like an extra party, I'm going to answer in a couple of different ways here, because it depends. So if you have 3 parties or 4 parties or 5 parties, you could have it all basically the same structure depending on what the use of the property is going to be. So you either have, for example, that mock stratification that I got into earlier, where you have, if there's 5 different units, 5 different parties, it works the same as if it's 2 different parties. Where it can get a little bit more complicated is if you wanted to have, for example, if you had two units and then a third party being an investor only, and how that investor relationship works, and that can be worked into an agreement. It's certainly doable. It would just address the fact that these 2 of the 3 parties have the right to occupy the property. The third party does not, and is more of a silent investor in the property. And then with respect to your second question, if you have 2 separate, and I'm guessing what you're referring to is 2 separate legal titles in 2 different that are next to each other, or might not be next to each other at all, they might be in different locations. Do you have a co-owner, like if you have multiple different investors in that, how a co-ownership agreement would work? And that's more complicated, and it depends on whether or not you can get financing for a corporation or not. If you can, I would recommend going with more of a corporate structure route, especially if there's a consideration to potentially be buying more properties. You would then be able to buy and sell shares of the corporation a little bit more easily. You can have a shareholders agreement in place for that would specify how dividends are to be paid out if it's going to be by rent. But I'm making some assumptions here, and that it's going to be a rental type of investment structure. But the problem with that is that financing for a newly created corporation can be really difficult. So if you can't get financing, then I would recommend more of an investment type ownership structure, which basically just refers to 2 or 3 or 4 different properties and how those properties are going to be dealt with, assuming that they're all going to be dealt with in the same way. If they're going to be dealt with differently, then it might be necessary to have two separate co-ownership agreements or a co-ownership agreement for each different property set in place. So does that answer your questions, Emily?
And I'll just add, right, that the decision often of whether to be this partnership, tenants in common setup, or whether to go a corporate or a co-op structure really often comes down to financing and resellability and some of the trade-offs that come with each of these products. And we can certainly help you navigate those decisions as you go through the process, and then figure out which makes the most sense for you in given the number of co-owners, the financing structure, the frequency of sale, and that will dictate a bunch of those questions. We got a similar version of it in the chat, where it says here from Walter, you mentioned like shareholders a number of times. So what ownership structure, informal partnership, LLC, corporation, I'll add co-op, should we consider in setting up a co-ownership agreement? Do you have any kind of insights into the pros and cons of B Corps or co-ops or just standard LLCs? I mean, it's going to be a case-by-case basis, I assume, but.
Yeah, it definitely a case-by-case basis. And when I refer to shareholders, I don't necessarily mean shareholders of corporation. I might just be referring to shareholders of a house. And apologies if I mixed that up where it may have caused some confusion, but I would say that where I'm more referring to a shareholder type structure is where it's an investment in the property, and you have multiple different individuals that are contributing multiple different amounts. And in that case, I would be more of a corporate structure, or a shareholder agreement would be the comparative that I'd be referring to. There, co-ops are a whole different beast, and I think there's been a long time since a co-op was created in Vancouver. They're more common on the islands, and even then, I don't have my feet on the ground enough to know even if there have been many that could being created more recently. But what I see sometimes is a corporate structure that it might own property through shares, and then a separate. So you either have a lease that's set up where because you own a share, you automatically get to lease a certain spot, or a co-ownership agreement that's also included as basically the shareholder agreement for the corporation. It says, as a shareholder, you're entitled to a license to occupy the space. So there's all kinds of different potential options there, but yeah, when I refer to shareholders, I'm more referring to just a standard corporate structure as an owner of the property.
Emily, I saw you unmuted there for a minute. Did that answer your question, or did you have a follow-up?
Sorry, it mostly answered it. Really, I was thinking more sort of like intentional community more than investment properties. But I think that it's the same answer regardless.
All right, thank you. Ava, thanks for raising your hand.
Hi, everybody. Thanks, guys, for putting this on. This has been really informative. I had a question about the mock stratification system, which is intriguing. Can you clarify that under that arrangement, if one of the parties renovated their unit, so their value or the value of their unit increases, that would result automatically in an increase in their share of the property, like that's built into it?
Yeah, so the way that it would work, there's a number of different alternatives that I've gone with in the past. So basically what you'd be doing is saying dependent on what the upfront percentage ownerships of the property are, if one party decides that they want to put money into the property and do a renovation, The way that it would work is you would do an appraisal of, in fact, what probably the way that I should have clarified it, and maybe this is why there's potentially a bit of confusion there, is you would do an appraisal of the property as a whole up front, and then you would also do an appraisal of the property after the fact. You would need a market base to determine whether the market changed over the course of that time. But what we're trying to determine is, what did that party's investment into the property do to increase the property as a whole? And that party should be getting that share to themselves. So that then being the basis for your distribution of percentage ownership interest. So you're locking in, so basically doing an appraisal up front. Let's say it's 64, I'll give some numbers. Let's say it's 60-40 up front. The valuation of the property as a whole is $2 million at that point. Say it's a really significant renovation. So I'm not good with numbers, so I'm going to give an even one. And the property after the renovation is worth 2.5 million. So that the non-renovating party's share of the property stays, if they're a 40% owner, they would stay at $800,000, which would be 40% of 2 million at the time that it was renovated. The renovating party would then become the owner of the remainder. So 800, sort of 2.5 minus 800. So we'd be at 1.7 million for their share at that point. And that would be the basis for your future percentage ownership interest going forward.
Okay, so you would actually want to get a new appraisal when the renovation is done to determine the new numbers.
That's right. So it's primarily in place for major renovations. It wouldn't be necessary, like if you're just going to be replacing the countertop, for example, you wouldn't want to necessarily go through this whole process of determining upfront and afterwards what the difference in valuation is going to be. If the parties can agree, and that's an important note as a whole here, if the parties can agree at any point on something other than what the co-ownership agreement says, they're welcome to do so. But there needs to be that baseline in place in case a party decides that they want to pour a whole bunch of money into the property and want to make sure that they get their money back.
All right. Thank you. We got a lot of questions coming in. I'll go to the chat now. A married couple jointly owns a house. They decide to divorce. Can they enter in a co-ownership agreement and change their joint tenancy to tenants in common?
So that's, I think, more of a family law question that I can't really get into. If a married couple owns property, they get divorced and they want to switch it into tenants in common, is that the question? No.
Yeah, as I understand it, at any time you can change a joint tenancy to a tenants in common.
That's right. Yeah. Yeah,
So
there's no issues if at any point you want to go from joint tenants to tenants in common. The impacts on the basis of separation, I can't get into, but certainly there's nothing that would restrict somebody from going from joint tenants to tenants in common at any point.
yeah, so the answer is seemingly yes, but you have to be in a good amicable divorce that you can,
Yeah.
stick the landing.
Yeah.
All right, Martin, please unmute yourself and ask your question. Thanks for joining us.
You're most welcome. Thanks for hosting. A couple of things. One, Ryan, you mentioned the existence of hybrid ownership structures and then kind of didn't really go into it. Now, Noam at least shared with me and a number of others a house up near Commercial Drive that sort of has a separate occupancy group and ownership group. Would that be one? If so, is that sort of a normal way to go about that, or are there other sort of standard things that we should be considering? B, as far as maintenance is concerned, in a strata, you'd sort of have a monthly fee that you'd pay to your strata for large things and all of that sort of stuff. Is it common to put something like that into a co-ownership agreement, or are there better / different ways to go about that?
Okay. I'm gonna answer your second question first. I might get you to repeat the first one. I didn't quite catch the first bit of that, but with respect to, so when you're doing a mock stratification and you want to have different parties responsible for maintenance expenses, for example, You can handle it really, it can be as formal or as informal as you'd like. Now, there are stratas that are non-conforming stratas. So duplexes, for example, don't have to have strata fees in place, or triplexes, or even quadplexes. Those are not required under the Strata Property Act to have, well, to adhere really to a lot of the requirements that the Strata Property Act requires. So fees are just as they come up. If you have an expense for the property, it's paid as it comes up, which is why you would have, when I was referring to like risk or liability for expenses and requirements, or sorry, for if one party, for example, wants to make a payment towards an expense without getting the other party's consent up to $1,000, that would be one of those situations. However, you can also have in place like a reserve fund. So you might have the parties making a monthly payment towards a reserve fund that's going to be used to pay out all of these different expenses, or is just going to be, you might pay into that a big chunk into that reserve fund up front, and it's just going to be that amount is always going to need to stay at the $10,000 mark. So you might pull out of that, and if it does get pulled, to make an expense, parties are going to be paying back into it to get it back up to the $10,000 mark. So there's never a situation where there's a major expense that the parties can't pay, for example. So it's really, there's no, I wouldn't say that there's a best way to go there. It's certainly something that's up to the preference of the parties.
Fantastic. Thank you. So I have a question here from Emily. Is there such a thing as a nonprofit of people that co-own the properties?
Yeah, certainly. There's nothing that would restrict that, for example, if rent was coming, like if you decide that you want to co-own properties and rent at an amount that's just going to cover expenses, that's absolutely possible. There's nothing that would restrict you from doing that. Whether there's such thing as it or not, I don't know the answer to that. I'm not familiar, and I don't know of anybody that's gone into a investment on the basis that they're just going to be covering expenses. Although I suppose it happens with kids or with children a fair bit. So that would be an example that I can think of. But yeah, I don't see anything that would restrict you from. Certainly, it's an absolutely possible situation, and it would be legally enforceable. Just because you're not getting a profit off it doesn't necessarily mean that there's not consideration flowing to allow for the contract to be enforceable.
We also see versions of fixed equity co-ops where you take the profit margin out of the ownership of real estate. So you can buy it now with the commitment that you can only ever resell it at what you paid for it, or what you paid for it plus inflation, or some fixed return. So you're choosing to trade off future profitability to increase future affordability for the next generation, or just changing the values around that. And of course, in BC, when we hear the word co-op, we usually think about rental co-ops, which are these, social benefit sort of co-owned products. But when we're talking about co-ops here, we're talking about ownership co-ops where you own shares in the cooperative building. Jay, I see your hand up. Please join us.
Hey, thank you. So my question that I just put in the chat was essentially what I was trying to get some more information on. I'll use my personal situation as a quick case study. My wife and I bought a large home last year on Vancouver Island. It's essentially 5,000 square feet, 2.5 suites. When I say 2.5 suites, we have a legal suite in the basement, 2-bedroom, 1 bath. We've also got an additional 1,200 square feet in the basement, 2-bed, 1 bath, kitchenette, large great room. We could easily turn this house into 3 suites. And then there is room on the property to build a coach house and create a 4th suite. The way provincial housing initiatives are going, this seems quite doable. I'm just trying to suss out I'm really unclear with what Premier Eby is doing. are we in a position where we could potentially turn our single family home into a fourplex or a triplex and stratify the whole thing, or are we limited to just creating additional rental units? I'd like to know which course of action I should pursue and really look into. I'm just really unclear how it's all going to flesh out in the next 6 to 12 months, hoping somebody's got more information on that.
Noam, you might have some information that I maybe don't have on that, but there's certainly, I mean, there's a push as a whole to allow for both more suites that, and also preventing from illegal suites being illegal that might not be stratified, but also pushing for stratification. In your circumstance, I think the applicability or the applicable change would be stratification might be more easily attainable. But there's a lot that's going to need to be dealt with before we get there. I know that there's been a lot of lobbying to make it happen as quickly as possible. But stratification, and maybe the one thing that I'll add here before I maybe pass it along to Noam and maybe David, if you have something to say here, is that stratification is it's superior option to co-ownership agreement if it's possible, with the one exception that once you stratify, your properties are individually worth far more than they were worth pre-stratification, which is part of why we're having this discussion is affordability. So once your property is stratified, then you're in the situation where you can sell off each unit. Those are each individually owned units, and there's full autonomy to do whatever you want in them. But there's a process to get there, and as you've alluded to, it might be difficult for your situation. It's difficult, I know, for a lot of situations that I know people that own property in Vancouver, and so it's also a costly process. You might have to put a lot of work into your property to get it to a state that these municipality is going to agree to stratify with. I know a lot of fireproofing is a big problem for a lot of the properties in Vancouver. And then there's just a straight cost. I don't remember what it is right now for City of Vancouver, but I think it's in the range of 12 to 14,000 for stratification. It might be more. But yeah, it's as a whole, it's a route that I would recommend going if you can get, like, if two owners are co-owners of a property, and at some point it's determined that they can stratify their lot. You know, I would certainly recommend going that route if it's an easy route to get there, because then you have the full marketability that we're trying to achieve. You have autonomy to do whatever you want, not whatever you want, but within reason, and you have the protection of the Strata Property Act.
I'll just say, I think you alluded to this, the big limitations that I see have to do with, of course, zoning. It has to be allowed, but that's where you're hoping that the province will change a lot of that zoning. And then as Ryan just said, the requirements, generally you need to bring a property up to full modern code to get that fireproofing and the sound barriers and proper environmental efficiencies and things. So it ends up being cost prohibitive in most cases, which is where co-ownership is the hack, right? So you asked, can I stratify or do I have to rent? And of course, my answer is, well, there's this third choice, which is co-ownership. And that's where we're coming in. I want to take this moment to introduce David Hale from Victoria and Shared Home Ownership Victoria. And again, another mover and shaker in this emerging field, who will introduce himself and maybe answer your question a little bit as well.
Yeah, hello. Thank you, Noam. And thanks for everybody being on the call tonight. We've got a great group. And Jay, are you in Victoria? If you are, I'm happy to have a call with you. You're talking about a very big topic, and there's 13 municipalities in the Greater Victoria area.
Sorry, we're not. We're Greater Nanaimo Regional District.
Okay. Brian works up that way, so maybe have a chat with him. But I'm always available too for a quick call. Yeah, I've been operating shared home ownership in Victoria for about 6 years, and I had one of the ladies that one of the 4 women that bought a home to share came to me a few months ago, I guess, and said, "Well, I'm thinking about putting an extra bedroom in my suite." So I went through a bunch of calculations with her to try to figure out, like, was it worthwhile to kind of renew their agreement? Anyhow, lots of fun stuff. Yeah, thank you, Ryan, for putting this great presentation on tonight. I'm going to steal some of your verbiage here, like mock stratification. That's great. Love that. Hypothetical appraisals. Merit trust, we didn't touch on that, but I know time is limited tonight. Yeah, just happy to be here, happy to be having these conversations, and yeah, fantastic work with putting these agreements together. Really appreciate it.
Fantastic.
Is there anything else you wanted me to talk about? No?
No, that's great for right
good.
now, but I'm gonna use this as a
Yeah.
bridge. We still have more questions in the chat and we'll get to them, but some folks will probably want to head out soon. So I'm gonna take a moment just to let people know a little bit about what's going on at Coho and how you can get involved, and then we'll go back to the questions at hand. So we've done a lot of different types of things. This is one of the points here, right? Every deal is unique, every situation is unique depending on the property and the co-owners. So we've been working on things like sell of half a house, or 2 or even 8 people coming together to buy, a collective with 8 small homes, houses with laneway homes, duplexes, multiple condos in a building, all sorts of farmland for co-ops. We're really working across the board here, and Ryan is as well. Right now we do have a half a house. I have a house for sale that I'm selling in Vancouver on behalf of a co-ownership. 2 people, one of them is ready to move on, the other one wants to stay. So they've come to me to find a new partner to move in. If anyone's interested, please reach out. It is on MLS right now. We're doing viewings on Sunday, but it is really exciting to see this resale of property shares happening. People used to always think that when you wanted to end your relationship, you really had to force the sale out. And now we're seeing that you can resell these shares and allow one of the parties to stay on board. And these legal agreements are key to creating the infrastructure to allow that in the future. There's also a unit for sale. This one's currently under contract, or hopefully has its buyer. But Brian has a unit for sale, also half a house, or a third of a property with the rights to half the housing, half a duplex in Arrington outside of Nanaimo. So really kind of interesting deals. We have groups forming. One of my things I'm most excited about is the idea of collective living and co-ownership within co-housing. So we didn't talk about co-housing today, but it's a larger form of stratified but collective housing. And we're working with co-housing groups, particularly one in Langley right now, to set up community within community and affordability within the larger community. Really an exciting project. We've got projects on Pender. And we have groups forming all across the province. So depending on where you are, be in touch with us to find if there's a community near you, or if there's people in our matchmaking network near you. If you're looking for a partner, we do have matchmaking services. We have an online partner survey that we encourage you to fill out. We have classified ads that you can see if there's anyone who matches your needs. We can build one around you. We do shareable homes tours in various areas, a chance to see properties. And also meet other potential partners, and then again, one of our realtors or members of our matchmaking squad can talk with you about your area and your needs, and see what we can do to get you set up. Here are some examples of the current classifieds. I won't dwell on this. You can go to the website and find them, but they range in areas across the province. They range in age and styles and needs and financial abilities. Really based on the diversity of society, which is all over the place. So we encourage you to get involved with Coho. If this is your first time here today, to visit our website, where there are a lot of resources, particularly our guide to co-ownership and our YouTube channel, which has, this video will be up there after, and there's many others, interviews with other professionals and with people who are co-owning about their experience. I mentioned all of the partnership stuff. And then, of course, you can schedule a consultation with us about your particular needs. If you are a first timer here, you also should make sure you come to our July 11th, What is Co-Ownership and How Can It Work for Me info session, or watch the video, which will be sent to you when your name is added to our email list. It goes into a lot more detail around the financing, around the housing types, around the process, around the how do you find a partner. We really focus today on the legal stuff, but there are a lot more pieces that go into this. But before then, we have a lot of really exciting events coming up. So if you're in the Victoria area this weekend, you can join David on a Victoria Shareable Homes tour. If you're in the Nanaimo area, whoops, a typo there. Gabriola Island Shareable Homes tour on Sunday. Really, there's a lot of excitement, enthusiasm on that community as well right now. And in Vancouver, we've done a series of East Side tours over the last few months, and this month we're doing a West Side tour. So these are chances, again, to see the types of housing that's out there, to understand what's available in your region at your price point, and to meet other potential people doing it. We also have some of our online event series. Conversation with co-owners is a great chance to hear from people who are already co-owning, hear about their successes and challenges, ask your questions of them, and just, really personalize this, make it feel a lot more real instead of just a theory. And then we have on June 20th, our matchmaking event, Let's Make a Co-Home, where we will break out into groups by region and get to know each other a little bit. And again, see if there's any potential partners there for you to set up housing with. But if you're not looking for a partner, then do reach out to us directly. And most of us here work as real estate agents or as lawyers, and we're available to you to help you find the right property, to help you create a legal agreement if you are already in a property, or if you're considering something with family or friends, to bring them onto your property. If you work with one of us as a real estate agent from the beginning, we can get you set up with a lot of these questions answered well before you get to Ryan, so that you can streamline the process. So that's, we look forward to seeing you guys at future events. We're really glad for this amazing turnout. But enough of me talking. Let's go back to the questions and the reason why we are all here. So, Alan, why don't you join us? Thanks for being here today.
Oh, yes. Hi, Norm. And hi, Ryan and Dave. I have a quick question. I have a 20% ownership in a collective house in Yarrow, and I rent my space out. And the owner that lives there has been trying to get along with my renter for a long time, and we come to a point where we sort of realize that she can't live with him anymore, and we have to try to get rid of him. But he doesn't want to leave. Is there a way to get rid of a tenant in this kind of a situation? Or is that a question that I should be asking you directly?
Yeah, we might want to reserve that for a conversation directly. We're dealing with Residential Tenancy Act and potential consequences of eviction and that sort of thing. But my email is actually on the page right now, so feel free to fire me an email, and if I can't help, then I'll certainly refer you to somebody who can.
Okay, sounds good. Thanks.
Yeah.
Thanks, Alan. Thanks for being here.
No.
All right, so we'll go to the chat. There's a bunch more questions in the chat here. So first was one more for me. Will the PowerPoint be available to us after the call? Certainly the video will be. And Ryan, I'm assuming if people want to reach out to you, you could send them a copy of your PowerPoint.
Yeah.
Is there such a thing as oh wait, we already did that one. What if there is not a fit with heirs after a death, or not a fit with an incoming spouse? How do you protect against that?
Yeah, so the default is generally that. So what we're gonna, it depends. The short answer is it depends on how and who your relationship, or who the people are that you're in the co-ownership agreement with. So what your relationship is like with them. If you're dealing with parents and children, of course, you might have a different restriction than if you are dealing with third parties entirely. if you want, like there are options for including, for example, the option for the survivor to either buy out that party's share or have potentially have not included this before, but you could include this if you wanted to customize it this way to be to basically say that you have the right to prevent that party from becoming an owner through a vetting process. So, and specifically, if that was going to be the case, I would recommend having a set of different attributes that you'd want to be considering. So financial stability and ability to take over that party's mortgage or loan. Those kinds of things might be things that you would consider on whether or not that the surviving owners would have the right to have essentially an option to buy that party's share out and liquidate it. And then same thing, that it's even more the case that the default for a spouse would be that they don't automatically get to become owners, that the other parties should have the right to basically have a veto against that, but that's certainly something that could be included in the co-ownership agreement, would be an automatic right if the party has a spouse to split their share in half and allow the spouse to be a co-owner with them.
All right, and the spouse, of course, would have to sign on to the co-ownership agreements at that
Absolutely.
stage.
Yeah.
In the situation where A can pay cash for their half and B has only sufficient funds for a down payment on their half and will need to finance the rest, what are the special considerations?
So in a situation where A can pay cash for their half and B has sufficient funds for only their down payment.
So basically,
so
differential
not,
down payments.
yeah, not really. Like ultimately you still have the responsibility to, or you have the responsibility to pay your share of the mortgage in any situation. So if you have inequitable amounts that you're bringing to the table up front as capital contributions, and therefore inequitable mortgage amounts in comparison with your proportionate ownership interests, it should be structured in no different way than if you had two different properties. One person has a mortgage, one person's just cash. You have your responsibility to pay your mortgage. The only special consideration I would say is I always recommend that there be something in place to restrict one party from being able to mortgage their share above 80% of the value that they have in the property. But no special considerations other than to say that each party has a responsibility to pay their share of the mortgage.
So Ryan, just to clarify that, you've got a $1 million property shared by two people, someone coming in with 500,000 cash and someone coming in with $100,000 down payment. Now, to my understanding, everyone needs to be on the mortgage, even the person coming in with the cash. However, the financial obligation to that mortgage is 100% on party B.
That's
right?
right. Yeah.
Okay.
And that's the model we work with mostly here, on the Coho crew. But there, as I say, Ryan mentioned earlier, there are also models where you could say, oh, I'm coming in with 500,000, you're coming in with 100,000. I'm going to own 78% and you're going to own, or 72%, you're going to own 18% or whatever it is, right? If you were doing this as a rental property or some sort of investment platform, you might choose a model where your investment dictates your ownership share. But if you're doing a co-occupancy model where each of you have an equivalent suite, then you are more likely to do this sort of model where you own 50-50, and then you're each responsible, whether it's in cash up front or through financing, for your own half. So again, there are choices here to be made on fundamentally what the property is going to be used for, what responsibility you have, what you think is a fair allocation of the two of you, because there are choices that could be made. But mostly we see folks doing this model that you're suggesting here, which is I have my half in cash and you have your half, part in cash, part in financing.
Right, and then a big thing to consider is the person coming in with the 500,000 cash with no obligation to the mortgage. Their name is on the mortgage, so to provide security to that person, right? That's a big part of why we're here tonight, is to provide security to all of those uncertainties. So can you clarify what that security looks like in the co-ownership agreement regarding any type of default from the person who has that financial obligation to the mortgage?
So like ultimate security is the exit strategies. If a person is in default, they are obviously obligated to pay, and first step would be arbitration to have that party responsible to pay. But the ultimate backstop and the ultimate security here is the ability for one party to say, look, you're not making your payments on your mortgage. We're starting to get demands from the lender that they intend to potentially foreclose on the property. And so I'm going to take immediate steps under this co-ownership agreement with respect to my as the rights that I have to buy you out. I'm going to take out my own mortgage and basically refinance your share and use that mortgage to pay you out and get you out of this co-ownership agreement.
Right, but typically when these collaborations, it's friendship and it's a friendly type of, sometimes people lose their job. So then what we recommend is, and I wonder if you would recommend it as well, is to have one part where you do have that initial reserve fund at the beginning in case of hardship, whatever may be the cause of that hardship, where the one party supports the other party out of that fund, to give that person some breathing room to get back on track. And then as far as step one in delinquency, that's what we recommend. So because a lot of people are backing away from this because this is a huge topic to consider when one party goes into delinquency, that they don't want the person who isn't going into delinquency can affect their credit rating if that mortgage goes into default. And that's what we want to protect, is everyone's credit rating as well.
Yeah, and certainly well before that, the steps that I was talking about would be taken. There's the right to perform another party's covenants is the name of the clause that I would recommend including, which basically says that one party has the right, but not the obligation. If they choose not to, they don't have to. But if one party is not making their payments, the other party has the right to make that party's payments on their behalf, in which case there's going to be a deemed loan created. And there would be a set of parameters for that loan set out in the co-ownership agreement that would say, this is the percentage of interest that I'm going to be charging if I'm going to be going into debt to pay your expenses. And then also the right to potentially refinance that into a more structured promissory note or loan that is going to have a repayment structure. So depending on how formal it's you want to make it, at the very least, there needs to be top terminology in there that does deal with deemed loans. But at a greater extent, there could be, as I say, basically a written into the co-ownership agreement that says that when if or when the deemed loan hits a certain dollar amount, it's going to automatically create a case of default, and there's going to be, there's different ways you can deal with it. There's going to be a loan created with a 30-day repayment window, and if that doesn't happen at that time, then the property will automatically be sold.
There's a long question here from Christine that I think I can simplify fairly quickly. Christine is asking about joint tenancy, about with the right of survivorship. And now mostly in co-ownership situations, again, except for couples, we discourage joint tenancy. Most people are trying to protect their personal interests and their heirs' interests and the rights, their own individual rights. But she presents a situation where they intentionally want to have a last right of survivorship on the property. And so just you want to confirm that you have 3 joint tenants on a property, A, B, and C. A passes away, the property automatically becomes B and C's.
Yeah.
B passes away, the property automatically becomes C's. C passes away, the property gets inherited by C's heirs.
That's right.
And B and C die concurrently, or A, B, and C all die in one tragic accident concurrently. It gets distributed between the heirs of all of them, correct?
Not necessarily, no. So if that's a more complicated question. If they all die in a car crash concurrently, then there would likely be a determination of who died first. it's not necessarily going to be distributed in accordance with, like split amongst their heirs. So that's a complicated hypothetical that I don't know for sure how that would work in terms of determining who died first, but it's always, there's no situation that I've ever come across where there's been an override of the structure where it goes through to the heirs. There's always, and if I'm not mistaken, it's either, it might even be I don't know if it's in the Wills and Succession Act, but I think it might be statutorily defined on how it works if two parties die at the same time in a car crash, or if there's the inability to determine the time of death for parties. If it may be by age, I'm not totally sure, but it's almost always whoever is the last survivor, it goes to their heirs. It always is. I can't, as I say, I can't think of a situation where it wouldn't be.
Okay. And of course, something to keep in mind if you argue something like that, that not only does the value transfer on, but so does the responsibility. So if you have a joint mortgage in a situation like that, and one person passes, the full responsibility of that mortgage will pass on to the other two. So just something to keep in mind when you're creating a structure like this, what your goals are, what your long-term goals are, how your estate's going to feel about you doing a thing like this, so that you don't get them into legal trouble when your heirs sue for the fact that you've given up your rights to the property, things like that. But
yeah, and to touch once more, there's the only time that I would recommend joint tenancy is in the case of spouses, or in the limited circumstance, this is case by case, but for estate planning purposes where somebody's going to die. But that's a case by case basis that I would need to recommend on an individual points. If you're going into the property with siblings or friends or anything like that, you should not be going joint tenancy unless there's a reason that a lawyer said to do otherwise.
Laura says she has seen a time where people died close to each other and the estate was split. But anyways, it's a rare occurrence, and it's if you're doing the joint tenancy, I guess doesn't really matter in the end. We're going to take the last couple questions and then we will call it a night, because everyone has been here a long time, and we really thank you for coming and for sticking with us. The video will come out and be available if you want to rewatch it. But most importantly, our contact information is here. Please reach out to us about your situation, and we can get you set up with the right housing, the right communal structure, and of course, the right legal structure. So the last couple of questions that I see here: if a group is gathering to build a co-ownership community, can funds be collected and held in trust while the community is forming? The funds will eventually be used to buy a specific piece of land or property. And I guess I'll add or returned if nothing is purchased. That's a model that can easily be done?
Yeah, I don't see why not. There's, there are, then you're getting more into an investment into a corporation in a way, like you're putting funds into a legal entity that's going to then distribute it according to how the owners of that entity want it to be distributed. But yeah, I don't see why that wouldn't be possible.
And we didn't get to my questions because there were so many good ones from the table, but this was one of them, and I'm glad Laura brought up at the end. How much money does it cost to develop a partnership agreement, and how long do you need? How long does the process take?
Yeah, I mean, the answer is it depends. I certainly can't. There's no two co-ownership agreements seem to be the same. Much as oftentimes I wish they could be, and it would be easier for everybody if there were more of a set structure, but they all depend on the specifics of the unit. We've talked about a bunch of different structures and hybrids of those. So as a whole, I generally recommend a budget in the range of $2,500 in legal fees for preparations of co-ownership agreements. It can be more or less. It can be much less if it's a super simple structure, and it can be more if it gets really complicated and we're dealing with, a complicated loan structure that's going to be in place, and the development of a property, and the definition of co-ownership can really expand. So it's, as I say, it's really tough to give an estimate. I would hate for somebody to rely on that and then I come back with a quote that's much higher. But I would say as a whole budget for about that range. And then in terms of timelines, it depends on my availability. It might be this situation where I have, if somebody comes to me and they need something urgently, I might have 10 already on the go, 10 ownership agreements that are fairly urgent. So it depends on my availability. There are other lawyers at my firm that could potentially jump in if there's the need to do so, or our firm does have other lawyers that that I work with on these ownership agreements, and I could have somebody team up with me. But I would say budget for 4 to even as long as 6 weeks, and that's not necessarily accounting for different lawyers reviewing on behalf of other parties, because it's not always that I can represent all of the parties. If there's a situation where, and I've had many situations that have kind of gone sideways where there's a disagreement over terms, and I can't give the same legal advice to one party as I can the other. In that circumstance, I'm either required to only represent one party, or in one situation I can think of, I was just required to remove myself entirely and refer each of the parties to different lawyers. So having a different parties share reviewed by their own independent lawyer is always a good idea, and it's something that I would always touch base with the parties on at the outset, but it can add to the timelines. So yeah, to be short, 2,500, 4 to 6 weeks is the budget, but it's the caveat is it depends.
And we do have other lawyers that Co can refer people to for that secondary advice who've done this stuff before. So you're not starting from scratch with a new lawyer. Which brings me to kind of 2 last points and questions. One was, this is, I guess, why this process should be started ideally before you buy your property, before you've entered into a binding contract to purchase a property, both because once you've done that, you've committed, even if there's this dispute, and 2, because you want to definitely make sure you have it all in place before you go and register the property on title, and this can take time. So we always recommend that, we will work with you to address some of the questions right in advance, so you know what you're taking to Ryan, but then also to start with him before you have an exact property in place. You concur, Ryan?
Yeah, always a good idea. And I'm happy to have a initial consultation to just run through some of the different ideas and talk about structures that might make sense. And yeah, it's always a good idea, and I'm happy to arrange times for calls and discussions.
And here's the last softball to end with. You said these things they're extensive and they need to be done thoroughly, but my buddy the lawyer says he can do a co-ownership agreement for $800, no problem. He learned how to do them in law school. Why should we be using you?
I'm guessing that wasn't actually a question, but that you're pulling something up here. I would say, it's tough to talk myself up. I don't like to put myself, I'm already a little bit flustered trying to even describe it, but I would say that I do a lot of these. I've seen all of the different circumstances. I've also been involved on the litigation side of them. I've seen how these can go sideways. They're all unique and they can be very complicated structures. And so having, you're gone through different styles and being able to recommend different structures is, I think, what I can help out with. But
yeah, it was
yeah,
and that's my point exactly, is that people tell you they know how to do a legal agreement, and that's fine. They learned how to do a business joint venture agreement in law school, but there's a big difference between a cohabitation, co-living, co-ownership, where this is your primary residence and your future, and all the considerations that go in socially, that go in around exit. It's a much more complicated thing than just buying with a friend an investment property for rental. And lawyers will tell you they know how to do it, but Ryan here does it. and identifies the new question to be asked every time. And it's a good insurance premium. It's worth the money, every cent of it, to get a strong legal agreement. It'll save you down the road. So thank you, Ryan. Thank you, everybody who came here today. We hope to see you at some of the upcoming events. And definitely reach out to us to talk about your specifics, and let's get you set up with the right home, the right community, and the right protective structure, so that everybody is always has a pathway as they need it, and everyone's protected. Have a good night. Thank
Thanks,
you.
Tom. Thank you, everyone.
Brian. Thanks, Noam. Bye, everyone.